and the respondent agree that transfers may affect union officials at branch level, and further that there is no agreement on transfer of union officials consistent with the union management and activities. It is submitted for the applicant that there would be no immediate prejudice if union officials are transferred within the geographical limits of their respective branches. The court returns that, pending such agreement to govern transfer of union officials, the union officials will be transferable within the geographic limits of the branch they are elected to serve, and the present transfer decisions outside such geographic limits are liable to being set aside. As there is no policy on timelines to decide appeals and requests for review of transfers with respect to appeals and reviews against the present transfers, the respondent the applicant will make decision thereon by 15th February 2019, and no such affected teacher will be victimized, intimidated, or harassed in that regard. As parties have agreed that promotion guidelines must be by way of regulation, Circular number 7 of 2018 of 2nd May 2018, which purported to abolish and replace the 3 schemes of service in the teaching service with what the applicant called career progression guidelines, is amenable to being set aside or implementation stayed accordingly. In conclusion, the application by way of the notice of motion 31st December 2018 is now determined with orders as follows: that pending the hearing and determination of the petition or further orders by the court, there shall be stay of the taking effect of the strike and the strike notice issued by the respondent 19th December 2018 as reinforced by the circular dated 30th December 2018, or any strike notice on the 4 issues or disputes as may subsequently issue, with the effect that the respondent by itself, its officials, members, agents, or any other person acting in that behalf is hereby restrained from implementing such strike notice or strike, and the strike as scheduled effective 2nd January 2019 or any date thereafter, as the case may be in that regard, is stayed, and the teachers affected by the notice shall continue on duty uninterrupted accordingly. That pending the hearing and determination of the petition or further orders by the court, the applicant and the respondent to attend the conciliation proceedings before the conciliation committee 9 o'clock in the forenoon at the Ministry of Labor and Social Protection, Nairobi, and for that purpose, the applicant's chairperson and secretary and the respondent's secretary general and chairperson to lead their teams respectively. That pending the hearing and determination of the petition or further orders by the court or resolution of the dispute through conciliation committee, whichever is earlier, 1. The applicant will determine appeal or application for review of transfer of any of the 3,094 teachers as currently transferred, not later than 15th February 2019, and no teacher who so appeals or seeks a review will be victimized, harassed, or intimidated in any manner. 2. Pending an agreement on transfer of branch union officials beyond the geographic limits of the branch they are elected to serve, the decisions to transfer any of such union officials, and as per the list in Exhibit WS9, is hereby stayed, as such transfer beyond the branch territory is now set aside. There shall be stay of implementation of the career progression guidelines, being circular number 7 of 2018, of 2nd May 2018, and pending agreement in that regard and enactment. Promotional decisions to be made as per the collective agreement and the prevailing regulations or such other regulations as may be promulgated as per Section 35(2) of the Teacher Service Commission Act 2012 on career progression and professional development programs as may be prescribed by regulations. As teacher professional development program has not yet been implemented, parties to engage in accordance with Clause 12 of the collective agreement towards appropriate teachers' professional development modules and policy. Parties to engage by Clause 11 of the collective agreement towards tools, instruments, processes, and procedures on performance management, and the same be implemented only after such agreement and promulgation of the relevant regulatory provisions. This case will now be mentioned 17th of January 2019 at 9 o'clock in the forenoon or soon thereafter to report on the progress of the conciliation proceedings and for further directions on the petition. The course of the application shall be in the cons, and that is the ruling.
Is this? I think that largely the orders are reasonable, and we'll do everything we can to comply with the orders of this court. One issue, my lord, that calls for consequential directions is the order relating to resumption of teaching. My lord, the respondent, Kenya National Union of Teachers, does not wish to be placed in a position where they violate the orders of this court whatsoever, inadvertently or otherwise. We want to comply so that the consequential direction that the respondent Kenyan National Union of Teachers seeks, my lord, is that your lordship accepts, accords them time between now and Sunday to remobilize their organs. My lords, the elected officials of Kenya National Union of Teachers do not communicate or speak to their members through the media. They've got their own procedures of communicating down their structures, down to the branches, so that every teacher gets to know that he or she should report to school. It is not possible. It's now already 6 o'clock. At the national level, the Kenya National Union of Teachers needs to sit and begin this communication cascading downwards to their members. Because, my lord, before a strike is called, there are a lot of consultations. It's not the people in the national office who decide to call a strike. It's the involvement, it's the participation of the members. And therefore, we want the reverse of that process. And we are not asking for any unreasonable timelines or amount of time. We would like clarification with regard to the order for the teachers go back to the classroom. And they do so.
Are they supposed to go back to the classroom?
Solomon?
When are schools opening? When are they supposed to go to class?
Well, they were supposed to. It's already passed. was supposed to be, I think, tomorrow. So what we're asking is, in order to do this in an orderly manner without violating the court order, they go back on Monday the 7th. And we will be able to communicate very effectively to every teacher that following the orders of this court, go back to the classroom and ensure you begin teaching with effect for 7.
Who sets the date for opening of schools?
Well, you see, when there is a dispute like this one now, your lordship, it falls on the shoulders of your lordship, because you are the one ordering us. We would have preferred to go on strike until our issues are resolved. You have ordered that we must not go on strike. We go back to the class. We have complied, we want to comply. All we are asking, with effect for Monday, the 7th of January. That is not asking too much. With regard to all the other things, we agree, and we are very happy that you've given a mentioned date. You've also given a date on which we should appear before the conciliator. And in particular, your lordship has very appropriately directed the individuals who should represent TSC and the individuals who should represent Kenya National Union of Teachers. And I say that is the wisdom of Solomon. Because if there is any violation, if there is any breach, your lordship will know who to send to Kaneti or to Langati. Because those are the individuals you have said should now assume the mantle of ensuring these 4 items are discussed and agreed upon. And we are happy to do that. That's all we've been asking. I thank you.
My Lord, in a short reply. My Lord, you have made your orders. You have made your ruling. You have read the ruling and everybody has understood your ruling. My Lord, I'm constrained to oppose the application by senior counsel that schools open on 7th January 2019. My Lord, for your information, these proceedings are live.
The schools open on
7th January 2019. My Lord, these proceedings are live on national TV. Every corner of this republic has understood your orders. My Lord, court orders are not subject to discussions by National Executive Committee of a Union. Court orders must be obeyed the way they are. My Lord, for the record, you stayed the strike until you read your judgment. The strike was not there because this honorable court and the senior counsel has been on record for respect of court orders. The strike was stayed until you read your judgment. So there was no strike. Nobody was willing to go on strike because there was court orders. You have reiterated that our children go to school tomorrow as per the term dates set by the Cabinet Secretary for Education. My Lord, the Cabinet Secretary for Education is not subject of these proceedings. You are being invited to extend the term dates. How will the children of this country recover for the lost 1 week? Academic programs in this country are programmed according to the term dates. Your orders must never be subject to negotiations and meetings at KNUT headquarters. Let your orders flow from the capital city of Nairobi to West Pokot this afternoon. And now they take effect immediately. We cannot go to KNUT House and discuss how to talk to our branches. The branches can be talked to through SMS. The branches can be talked to through WhatsApp. The branches can be mobilized through email, so that the best interest of the child, the parents who have bought school uniforms, the parents who have already boarded vehicles, traveling to their respective schools so that they open tomorrow, are not turned away that the High Court has ordered that the schools be reopened in January, next week. My Lord, good governance under Article 10, a principle and a national value of this country, requires that school dates are orderly, and the High Court of Kenya has reinforced that. My Lord, the invitation is not in good faith. Let your orders not be discussed. Let our children open the schools tomorrow. My Lord, you have made orders which are cutting across the board. Some bad for the union, some good for the union. Some bad for the employer, some good for the employer. My Lord,
how do you judge the goodness of an
my Lord, looking at
the court looks at the justice of the case.
Yes, my Lord.
Yes.
My Lord,
so I don't know in this scale of weighing things.
Yes.
How goodness and badness comes in.
My Lord, sometimes the court orders pain, but their court orders we have to obey them.
Yes.
Because the court looks at the interest of justice. My Lord, give us an opportunity to apply. If there is any party has something that may hinder the effective processing of your orders, my Lord, we can.
In terms of senior counsel's application?
Not at all. I've finished with senior counsel's application.
Yes, so now you are moving to another subject.
Yes. That, my Lord, you have made like an order that the union officials' transfers have been set aside.
Yes.
My Lord,
stayed or set aside?
Stayed for the time being.
It would appear that the parties had not been prophetic to see this day, that union officials may be required to serve outside their branches. Have you had a similar dispute before?
Not at all.
That this is the first time?
Yes, this is the first time.
So you must go and agree.
And agree.
On how this will be done.
Will be done.
And the justice is that let things be done the way they were done.
Yes.
Until changes are made.
Very well, my Lord. Then we, on behalf of the applicant, my Lord, I want to thank you for giving us a very detailed ruling this afternoon. We shall come back on the 17th. If there is any need, we may come back before that. But we are very grateful for listening to us and rendering a detailed ruling. Thank you.
My Lords, Mr. Oyucho, thank you.
I thought you had made enough submissions on your part.
We have just seeking one clarification on behalf of all of us, my Lords. And this is with regard to the date the parties ought to appear for the first time before the conciliator. It was not very clear to all parties that this
on the date to appear for conciliation.
Yes, my Lord.
Yes.
You should appear tomorrow, isn't it? The conciliation committee is waiting for you anytime, even today. So tomorrow should be convened at 9 o'clock in the morning. So tomorrow is on 3rd of January 2019. So it is, thank you. It is 3rd January 2019. Thank you, Mr. So now we can.
By the respondent about reopening recommended to the Ministry of Education, who are not the parties to this matter. And hence, that would be inconveniencing the children of this country who we are looking at their interest at this point. The children are ready to go back to school, and this is not about the teachers. The strike has been stayed because the teachers are expected back to school as of tomorrow.
Yes, Council.
I thought the ministry represented by the Attorney General, matters of this nature, they should be neutral, not partisan, with one side. Two, my lord, if it wasn't for your lordship's orders restraining the strike, there would have been no school reopening tomorrow, Friday, Monday, or any day, because the teachers of this country would have exercised their position. They had already called the strike. So this request that they are making is to make it orderly for a decision they had already taken and communicated to the teachers.